Well, Trevor Mallard.
Mr Speaker, I think that speech finished in a rather optimistic way, because I think if the Minister had been at all well briefed, he would know that the opposition is not supporting this legislation. We're certainly supporting the government to make this Rugby World Cup the best Rugby World Cup that we can have, but there's an outstanding issue that goes to the emergency powers that the Minister or the government is taking unto the Minister, which in our opinion is undemocratic and is wrong, and I will get into more detail on that, and unless there is an undertaking to reverse that, this bill, parts of it will be supported, but the second reading will be opposed, and those... Sorry? Well, I think the discussion around the Canterbury issues has highlighted the emergency powers, and I think it's fair to say that we've got more time to consider this. We've got more time to consider this, and as a result of that, we will not be supporting it. But I do want to say, Mr Speaker, my thanks go also to the officials. I think it's fair to say that we had a very good group of officials, including Parliamentary Council, working on this bill. And I think it's also fair to say with the leadership of the Chair of the Select Committee, my colleague David Parker, but also I think the active cooperation of members of the government and the opposition on this legislation. With the exception of the one issue, we've worked through the bill and come to compromises. Although I think it is also worth pointing out to the government, as I have done to the acting Leader of the House, that this bill includes a number of conscience provisions, and there are some issues which need to be dealt with there. And I think maybe before I get on to the main issue, I should signal the inconsistency between the arrangements that have been made here and the liquor and in the gaming area, for example, to do with cruise ships, the fact that cruise ships are going to be required to apply for this particular type of licence if they want to serve liquor, but they're not going to be allowed to have gaming licences. The fact that hotels will be allowed to extend their hours for liquor but not for gaming is an indication of the inconsistency that we have in this legislation, and inconsistency which I think all of which is subject to conscience votes. I might say, Mr Speaker, I'm a slightly cynical person, and I have a lot of friends who are involved in Sky City, but I think the efforts of the Sky City people in their lobbying and in their restrictions on anyone else but them being able to gamble during the night hours, and the fact that people in the large number of cruise ships that are going to be parked, the thousands, absolutely right, but we're extending drinking hours, Mr Matt, but not extending gambling hours in the same institutions are going to be open to drink. So now people can gamble for the same hours in which they can drink. We're extending the drinking hours, but not the gambling hours, and that was as a result. And for cruise ships, for example, we're giving them the opportunity to apply for these special licences, but not to apply for gambling licences. So there's inconsistencies here. And as I've indicated in a slightly cynical way, I think we saw the lobbying powers of people who are involved in the gambling industry. Well, the member says that the gamblers are not watching rugby. If one could also say that when the rugby's finished, therefore everything should close automatically at that time. And I don't think anyone's made that argument, and that would destroy quite a few good parties, although the member will learn more about that as he gets a bit older and reaches the age where he's allowed to go to the hotels. When Mr. Speaker, I do though, Mr. Speaker, want to focus on an issue which the opposition is taking very, very seriously. And I want to say to everyone who is watching this debate and who is looking to the opposition response that, notwithstanding what I said before about drinking and gambling and other things which will lead to this bill taking quite a long time to go through, this bill from an opposition perspective would go through very quickly if one particular clause was sorted out. And that relates to the ability of the Minister to override the authority which is set up under this bill in the later stages before the Rugby World Cup. And I might say an ability to override an authority to grant a consent is something that I wouldn't get that upset about. But in this particular case, what the government has determined to do is to have the authority headed by a judge, deputy head, lawyer, 7 years experience, to override their decision and to approve an application which has been turned down by the authority. And, Mr Speaker, my view is that that is just wrong. If we have a quasi-judicial process that has been set up, we have hearings that are heard, we have opponents, people for and against, and you have the decision, you have the planning decision that is made by the authority. The idea that a minister can override and say, for example, this historic home can be demolished. Minister has the right to do that. The authority can say no. It can be... Well, the member says it wouldn't happen. The member says no way. Why then is there a power given for that to happen? And more important, can we have one example from the next government speaker, just one, of the emergency situation where they think a minister's use of this power would be appropriate? Give me one example where a judge and the rest of the authority has said no, it is inappropriate to use this emergency power, and Mr McCulley on his own can say yes. I've asked this question on a number of occasions, and no one has been able to give me one example of where it is appropriate to do this sort of override of process. And remember, there are a lot of acts involved here. The example which I keep on using is a historic house that might be near to a fan zone or in a fan zone, and the question of the ability of the owner to demolish in circumstances when there wouldn't otherwise be the case. But there could be. Sorry. Well, my view is that as far as a road closure is concerned, if the authority turns them down, the authority is still required to have a hearing on a road closure. They consider all the evidence. You've got the town planning experts, you've got the roading experts, you've got the judge, and you've got the lawyer with 7 years' experience, and they say no. How can it be that the minister has more knowledge than them? How can it be that Murray McCulley knows more about roads than the people with the roading experience and the planning experience and the judge and a lawyer with 7 years' experience? So I think Nikki Kay has to think of another example, that she could bring up to say why Mr McCulley should be trusted with the ability to demolish houses all over Auckland, the ability to, and with no appeal, no right to go to court, no right to review, no right to a hearing in front of a court. He could make a declaration at 12, and at 12:05 the bulldozers could move in and do that job. And Mr Speaker, over the recommendation of a judge and a properly formed authority. It is a tiny bit of this legislation, but I'm one of the MPs left in the House, one of very few MPs left in the House who can remember Muldoon's Emergency Powers Act and his use of those emergency powers to control wages. to control wages and to do things which, Mr. Speaker, were wrong. Now, I have explained to the people who are in charge of the Rugby World Cup why we're taking this particular approach.